number 43, the people of the state of New York versus Omar Smalling. Good afternoon, counsel.
Good afternoon, Your Honors. I'm Janine Yunus from Appellate Advocates. I'm representing Mr. Smalling, the appellant. If possible, I'd like to reserve 2 minutes for rebuttal.
It is possible. You have 2 minutes.
Thank you, Your Honor. Your Honors, Mr. Smalling was deprived of a fair trial by the court's response to a jury note that provided a new ground for finding guilt that the defense...
Counsel, I just want to ask you a very basic question here. So if the jury is charged on the definition of possession, there's no objection by anyone, particularly defense counsel, and the jury sends out a note asking the judge to qualify something in the instruction. Why should the court be prevented from giving a meaningful response to the jury? I'm not...
I assume that you're referring specifically here to the dominion and control definition.
Correct.
The court was able to give a meaningful response to the jury note without issuing the constructive possession and acting in concert charge.
What would that have been?
Well, there are numerous options. For instance, ideally, the court could have said, I'm sorry, I shouldn't have mentioned the terms dominion and control. Those are actually irrelevant to this case. This is simply about physical possession, and repeated the physical possession instruction. Another option would have been to continue, but with the second part of the second part of that charge that talks about constructive possession, but not talks about property not in physical possession.
Did the defendant offer these options?
The defendant did not specifically offer these options.
So is the case really about ineffective assistance?
That is not how we see it. Defense counsel did amply preserve this issue. As soon as the judge issued the erroneous instruction, he protested. He offered what would have been a perfectly reasonable...
Object immediately, right? I mean, there's a dominion and control, I guess some part of that is exercised, but the dominion and control language goes in without objection.
Sure, yes.
And then I think it's on the second or the third where they're coming out and asking about it, then there's an objection. I think that's the Chief Judge's point. So it's charged as dominion and control, and there's no objection.
That's correct, Your Honor. He does use the terminology dominion and control, but it's also worth noting that the CPL 265.033 uses the term dominion and control in it when describing possession. And then in a footnote, it states that the rest, the constructive possession, should be charged where appropriate.
Perhaps I've misunderstood your argument and counsel's argument below. I thought the point was that the only theory available on the table was possession, physical possession of the gun. Is that true?
That's
okay.
correct.
So that's the first part of the instruction. And then doesn't it in the disjunctive say or dominion and control?
Yes, Your Honor.
So what was defense counsel thinking was appropriate about this additional language? If you've got already the whole, what counsel says, the theory, physical possession, why would counsel not be objecting to this additional language? I don't understand the point of that language.
It would have been better if he hadn't, but given that
Well, it may have been incompetence, that's what I'm asking.
Well, the CPL for that provision uses the term dominion and control when defining possession. And I think that's typically read even when constructive possession isn't the theory of the case. However, this was a unique situation where they had...
No, but I get that point. I understand fully that point. But again, I thought that what defense counsel and you, now appellate counsel, were arguing is that the only theory is physical possession, qua physical possession. And so once you've got this additional language, isn't that counsel allowing for exactly what happened here, which is the jurors saying, well, if it's not physical possession, what does this or dominion and control possibly mean? It must mean something other than physical possession.
As I said, it would have been better if counsel had objected to that language prior to the instruction being read, or at least prior to it being read again. However, given that he didn't, it was at that point the court's responsibility, seeing that they were focusing on this dominion and control language, which is just about constructive possession. It was the court's responsibility to ensure that they didn't seize on that and continue with constructive possession.
What about if the court had done what happened in the People v. Pilgrim case, the Second Department case? You familiar with that?
Yes.
Oh, okay. So if the court had done there, which said, oh, I made a mistake, I shouldn't have limited the charge to simply physical possession, and then he corrected the mistake, gave the instruction jury, and went forward, would you say that would be error?
That would be the solution, the ideal solution that I would have proposed.
Okay, but let's take a step back here. Let's assume for a moment that since you didn't object, I mean your side didn't object, to 3 different times when the court read out the charge, dominion and control, and only the last time when the jury came with, you didn't object during the jury charge conference when the charge was read, and then the 2 notes before you didn't object. It wasn't until the 3rd time out that there was finally an objection. At that point, the court felt that the court had to respond to a jury note, which I think you're hard-pressed to argue that a court shouldn't respond to a jury note when there's a direct question from a jurors on what's something that has been told to them 3 times and not been objected to. So at that point, I think, doesn't the issue really become whether or not the summation issue, where the defendant was arguably deprived of a right to pursue a particular theory in summation? That seems to me to be the stronger, a more viable argument from your point of view. I think you should address that.
Well, that's certainly the harm, was that the defense didn't have the opportunity to address this constructive possession theory of the crime, for which there was some evidence that the jury could have...
But wasn't his theory of defense that it wasn't him?
Sorry?
Wasn't his theory of defense that it wasn't him?
That it wasn't
somebody
him.
outside the car?
Well, I think there was some implication that it also could have been somebody inside the car, but...
Did he argue that in summation?
He didn't expressly argue that it was somebody inside the car, no. He said the argument was that it was somebody outside. But if he had known that this constructive possession theory would be charged, presumably, defense counsel even said something about, we would have said, we could have blamed this on Francis. The bullets were found in the back seat with Francis. There were credibility issues with regard to both Coley and Francis, the witnesses against the defendant. Both had motives to lie, and both had told the police different stories right after the arrest.
Chief, may I just ask one question? I know the
Yes.
light is on. A different topic. Is it your view that there was a reasonable view of the evidence where the jury could have convicted on constructive possession?
There was sufficient evidence in the record, I think, that they could have seized on that. And indeed, it's really important to remember that their notes indicated that it looked as though that was what they were finding guilt on. They kept asking about area, dominion.
Is this a case about constructive possession, or is it a case more about accessorial liability?
They sort of blend together. So it's constructive possession and accessorial liability. But because the theory of constructive possession would be, the idea, I think, is that the gun, if it was Francis's gun in the car, the jury might have erroneously thought that that was sufficient to find the defendant guilty. And if defense counsel had known that that would be sort of where they were going with this, or that the court would have allowed a finding of guilt on that basis, he would have explained in summation and maybe even asked questions on cross-examination to bring out that Francis having the gun in the car with the defendant was insufficient to constitute criminal liability for the gun.
Thank you, counsel.
Thank you.
Counsel?
Good afternoon. Jill Grossmarks for the People. A couple quick points. Number one, the court did offer defendant a partial verdict and a mistrial when it became clear that there was evidently one holdout juror. The court was told that the jurors were split 11-1, and it seemed that there was just one juror who was very fixated on this question of what does dominion and control mean. And what we also know is that after that, after it was rejected, the partial verdict, and then the Allen charge was given, what happens is then the jury asks for a readback on where the bullets were found. And we know that the extra bullets, the live bullets, were found only after an inventory control where the back seat is removed. So what that tells
But
us
see,
is that,
I don't, all those things are true, and they craft arguments for both sides in the case. But the fundamental principle, as I understand it being put forward, is when you do your summation, you should know what the court's going to charge. And if the charge changes, then your summation could not have addressed that. That's just the fundamental principle. The sequence is always the same. You always get a jury charge. You get a charge conference, and after the charge conference, your case is geared to whatever comes out of that charge conference. You know what's going to happen there. And here you were told weren't going to charge constructive possession. I frankly don't understand the accessorial liability and how that even applies in this case, to be honest. But I could just be wrong, which has happened before. But I don't see how someone can be denied the right to know what charge they're going to have in front of them, have that charge change, and have it not affect their summation.
understood, as I didn't focus on this because it seemed the panel understood where we were going with that, but Dominion and control was before defense counsel 3 different times. I don't
Was
think
it
counsel.
at the charging conference?
It
Did the
was
judge
not.
indicate he was going to charge Dominion and control?
It was not. But what happens there is now defense counsel does not ask to see the redacted charge. He does not ask what the redacted charge will be.
Well, counsel, wasn't it the people's position that they did not want a constructive possession charge?
It was the people's position.
And so when the court gave that charge, the people had no obligation to say, Judge, we didn't ask for that?
I don't think it's the people's obligation. I think defendant's attorney is the one who is zealously charged with focusing on defendant's concerns. And if defendant is concerned that by introducing that language, we're now getting into an
The
area
reason we're
where
here is that nobody
nobody
objected, right?
That's correct.
So we wouldn't be here if the people had said, oh, excuse me, Judge, we didn't want that charge.
We don't know why nobody objected, but what we do know is that
What
it's
did the judge say initially about that,
All
about
that-
constructive possession and charging on that? Or after the
Initially-
first request from the jury? Both times.
Initially, when the jury says, what does dominion and control mean? Or when the judge, when they ask, what does possession mean?
Both.
First time he says, okay, I'm going to define possession, he says, and he gives it, and then the next time, he says, but not constructive possession. Now, interestingly, when he defines dominion and control, he doesn't now say, but not constructive possession, which should have been a tip-off to defense counsel that now we're getting into constructive possession. I mean,
Doesn't that indicate that the judge knows that that's not what the charge should include?
the judge knew that, yes, but unfortunately, once
So
we're
how is it
into...
a meaningful response, knowing that the charge should not refer or include constructive possession?
It is a meaningful response. I don't think anyone can argue it's not a meaningful response when the jury wants to know. The issue is, was it an abuse of his
Well,
discretion?
but if they want to know about something that is off the table, isn't then defense counsel, appellate counsel correct? That fine, you have to explain to them what they are trying to determine, but you have to clarify that it's physical possession.
The court believed that that was going to confuse the jury further, and as the subsequent notes showed, we had an 11-1 split. There was really just one juror who was a little bit confused about dominion and control. And the reason I bring up that reread is once the reread testimony comes out, it becomes clear there's really no evidence, none, summation, what have you, there's no evidence that the guy in the back seat had the gun, none. His window is up. He's texting his girlfriend. We know that. He tells the police right away.
But
"My
there
girlfriend's
was
dead,
evidence,
dead."
evidence for constructive possession. He handed the gun to his wife, she had it, he had dominion and control over it and told her to throw it out the window. If we just accept the proof of that, that seems like a constructive possession.
There's no evidence that he constructively possessed it and did not physically possess it. There's no evidence that he exclusively constructively possessed it and didn't
So
physically.
you don't say that's constructive possession when he hands the gun to his spouse and tells her to throw it, and she's got it, and then she throws it out the
It
window?
doesn't matter to me because
No,
I
that's not
have
my
physical
question. That's my
possession.
question. Is that constructive possession in your mind? Does that meet the statutory requirements under the penal law?
Is defendant constructively possessing the weapon when my wife is holding it?
No, when he gives it to her, it says throw it out the window.
Okay, am I constructively? Theoretically, yes.
But is your point that you can't find that without also finding actual possession?
Yes, that is correct. And under Badalamenti and the other case law, there's no evidence to
Well,
support.
because your theory was he had the gun in his hands and then gave it to her.
That's
There's your
correct.
physical possession.
And the jury's verdict shows that. They didn't believe he was outside shooting, but they believed he had it. They believed he had the defaced weapon. They believed he handed it to her.
Did
They
you
found
ever-
not guilty on the 2 possessory counts, for heaven's sake. He got what he wanted. He
So
should have
you're
taken
saying
the partial verdict.
there's no evidence by which the jury could have found that the person in the backseat, Francis, had the gun?
That's correct. That is correct.
Because?
The window was up. It was the middle of January. Their windows were down. They were smoking. He's texting his girlfriend. His girlfriend is deaf, he says. He's texting her.
Well, that assumes the shooting from the car, right?
Right, okay, so if it's not shooting from the car, then there's no evidence to give it to Francis. Why? The live ammunition under the seat, it's nailed down. The seat has to come
I had
out.
thought that at the appellate division, did the people argue for constructive possession at the appellate division?
In favor of a constructive
Yes.
possession? You mean in terms of the sufficiency of the evidence?
I
Or-
thought that their briefs argued that, for the, that the facts supported a theory of constructive possession.
That may have been the argument in terms of the harmless error. I happen to disagree with that. And
Well, I
I
could see
don't think
that,
there's
but-
any evidence of that.
I see, so it's a different argument here.
That's true. Everyone's argument differed from the appellate division in this case, to
That's
tell you
fine.
the truth.
It's fine, it's fine.
Is there a difference between dominion and control and constructive possession?
They are the functional equivalent. We've said that. I think, are they identical? I suppose not. I mean, I suppose someone could argue dominion and control means grabbable area. I mean, theoretically, but in terms of the CJI, the language that the court used,
It's constructive
it's,
possession.
it defines constructive possession. To having dominion and control over something means I have constructive possession.
Whether it does or doesn't, certainly as charged, what it definitely means, or what it definitely doesn't mean is physical possession.
It definitely doesn't mean physical possession. And that's the only alternative charge that's ever been proposed here. And as I say, a mistrial was offered with a partial verdict. It was, and the other thing I would like to point out, I don't think counsel was ineffective. This defendant was acquitted of the top 2 counts, and the only reason that we're here, which is noted in their brief, is that this defendant, unfortunately, is not a citizen, and he's facing removal if this top count is not discharged, vacated.
Thank you, counsel.
Thank you.
Counsel?
If I may briefly address the mistrial issue, those were 2 separate things. The court offered the defense counsel a mistrial as a result of the deadlock, not having to do with the erroneous instruction. And counsel was entitled to this jury, that he had a hand in selecting, he had a vested interest in it. He wasn't, the fact that he did not choose to take the mistrial at that point has no bearing on the question of whether or not he was entitled to this curative instruction. As far as the,
But just on that, the deadlock itself could have been related to this instruction. So, I mean, it's really sort of hard to separate the 2 out, isn't it?
that's true, although, yeah, it does appear that that might have been what was going on, since all the questions were about dominion and control. But that again goes back to the issue of the evidence of constructive possession, which is that if there really was no reasonable way the jury could have found constructive possession, that doesn't explain why they were deadlocked. It was the jurors who assessed the credibility of these witnesses, and
But if there was no reasonable way that they could have found constructive possession, doesn't that go to harmless error?
yes, but there was a way that they could have found constructive possession. There was sufficient evidence based on the bullets in the back, based on the credibility issues of Francis and Coley, along with the, I guess those are the things essentially that, that could have allowed them to find constructive possession. And the fact that they were asking so many questions about this shows again that it seemed that that's what they thought. The acquittals were also.
That Francis was the one in
That
possession
Francis-
of the gun.
Yeah, or at least they had a reasonable doubt that it was Francis.
How was the ammunition found in the car?
Sorry?
How was the ammunition found in the car?
Well, there was the sock full of bullets in the back under the seat, and then I assume that's what you're referring to.
Well, She's mentioning something else.
There was also a shell casing between the seats, but that really doesn't have any bearing on, or it doesn't show either way. It could, who fired the gun or who had the gun.
Thank you, counsel.
Thank you.